So welcome back in the next lecture of public finance. So in the last lecture of public finance, we discussed about the recommendations of 14th Finance Commission, and we discussed the horizontal and vertical devolution. Then we discussed the second function of Finance Commission, that is the grants in aids. Then we discussed there are 5 types of grants which were given by earlier Finance Commission, and this Finance Commission didn't give any grants in aids related to sector specific and state specific. So this Finance Commission gave grants related to disaster management 55,000 crore, then grants to the local bodies 2.87 lakh crore, and then grants for the revenue deficit of the state, that is also known as the gap filling approach. So they gave 1.94 lakh crore. And then we discussed the small few other recommendations of 14th Finance Commission. They were like the PSUs, they divide into 4 parts, and then they discuss the municipal bonds, and there should be a regulator for rail, road, and all these things. So all this thing we have already discussed. So in the next lecture, we are going to discuss the reforms of public finance. Now, these topics are highly relevant from exam perspective, be it any exam. So these topics, just like the FRBMA Act, the amendment in the FRBMA Act, then the Insolvency and the Bankruptcy Code, this is highly relevant. Then the VAT, then GST, all these things are they are very, very important from exam perspective. So today we are going to discuss the first reform, that is the Insolvency and Bankruptcy Code 2016. So before starting this reform, first I want to cover this small topic of types of business organization. In Indian economy or in any economy, there are n types of business organizations. Like few companies they are private limited, few companies they are like public limited, few companies partnership, few proprietorship, Hindu undivided family. So basically there are 6 types of business organizations which exist in India after the Companies Act 2013. Earlier we had only 5 types of business organization, but now we have 6 types of business organization. So few points I'm going to discuss about all these types of business organizations. The first one is proprietorship. Proprietorship is nothing but it belongs to only one person. It means one person will be there, one promoter will be there, we can say. Only single promoter will be there, and he is the company and he is the owner of the company. It means there is no legal difference. If this person A starts a company, maybe Infosys, so there is no legal difference between A and Infosys. If suppose Infosys files bankruptcy, so A has to return all the money which Infosys borrowed. So A has to sell its even personal property, whatever other assets A is having. A has to sell these assets to repay the debt of Infosys. If Infosys borrowed 100 crore rupees from any bank, or if A borrowed 100 crore rupees from any bank, it is one and the same thing. It means there is no legal difference between the promoter and the company. It is one and the same thing. Whatever will be the profit of Infosys, that belongs to A. No partnership is there. Nobody else is there. If suppose somebody sues A, there is some criminal charges on it or something, it means that is having a direct impact on the company. Then the second type of business organization is partnership. Now partnership can be of 2 types. First one is the limited liability, and the second one is unlimited liability. So limited liability concept says, suppose this is company and the revenue of this company is again suppose 100 crore, and A started a company, but A's money, promoter's money, is only 10 crore rupees. But this company Infosys, they borrowed 90 crore rupees from somewhere else. Maybe from they took a loan. So they took a loan of 90 crore rupees. A invested 10 crore rupees, and A is the owner of the company or the promoter of the company. So the total is 100 crore rupees. But suppose tomorrow Infosys files bankruptcy. The functioning of Infosys fails. Infosys is forced to file bankruptcy. In that case, Infosys has to return this 100 crore rupees. but A's liability to repay is only 10 crore rupees. The remaining 90 crore rupees will be sold from the assets of Infosys. So this is known as limited liability concept, which means the liability of the owner or the liability of the promoter is only for the subscribed capital. This 10 crore is known as subscribed capital. It means the money invested by the promoter in the company, that is known as the subscribed capital. So this is limited liability thing. The unlimited liability says that there is no liability of A only till subscribed capital. A is responsible for full 100 crore. Even if Infosys borrowed 90 crore from somewhere else, but still, because A and Infosys, they are the same legal entity. So there is A and B, we can say. In case of partnership, it is more than 2. In case of partnership, it is more than equal to 2. So it will be by A and B. So 2 promoters are there. So if Infosys borrowed 90 crore rupees, but A and B, they have to return this 100 crore rupees. So this is known as unlimited liability partnership. And the first one is known as the limited liability partnership. The next one we have is Hindu undivided family. So Hindu undivided family, it is like a partnership only, but there are some minute differences. These minute differences, or we can say the major differences, these differences are, first of all, there are some conditions which you have to fulfill if you want to start this type of business organization. It is like the family should be together from last 3 generations. Who can be the promoter of this company? Only one family. In case of partnership, A can be an individual, B can be, maybe A is from Delhi, B is from some other state. But in case of Hindu undivided family, the owner A and B, C, n number of owners can be there, but they should be from the same family. There should be blood relation between A, B, C and D, or they are the relatives. The next thing is, suppose A is there, A is the owner of this HUF. Owner means the owner in case of HUF is known as Karta. It is usually the oldest male member of the company who is known as the Karta or the owner of the company. So in case of HUF, you have to fulfill some conditions like you should share the same kitchen, the family should be residing in one house only, they should share the same roof, then up to 3 generations they can become a member of this, or they can become the promoter of this company. But what is the positive thing about this HUF? The positive or the benefits of starting such type of business organization is you will get some tax incentives. These tax incentives is, in the taxation chapter we discussed that there can be 2 types of taxes. First one is the progressive tax and the second one was the proportional tax. We discussed even the example of progressive tax was personal income tax. In case of proportional tax, it was the corporate income tax. In case of proportional tax, even if your income is 2 lakh rupees, or your income is 10 lakh rupees, or your income is 50 crore rupees, you have to pay a fixed amount of that particular tax, and that is 30%. For Indian companies, it is 30%. So either your income is 50 crore, profit is 50 crore, 10 lakh or 2 lakh, you have to pay 30% of that. It means these small company whose profit is just 2 lakh rupees also has to pay 30%, and this also has to pay 30% of this. So if you are registering as Hindu undivided family, your tax liability will be of PIT and it will not be of corporate income tax. So if the profit of your company is 2 lakh rupees, you don't have to pay any tax, because in case of personal income tax up to 2.5 lakh rupees, there is no tax liability. Afterwards, then if it is up to 5 lakh rupees, then it is only 10%. 5 lakh to 10 lakh, it is 20%, and then it becomes the 30%. So it means if you are registering as the Hindu undivided family, you are getting some tax benefits. So this is known as Hindu undivided family. Then we have the private limited company. Private limited company is again a type of company under which the members will be 2 to 50. There cannot be more than 50 owners or 50 promoters of the company. So it should be more than 2 but less than 50. But one other characteristic of private limited companies, they cannot issue IPO. IPO means, I think in the first lecture we discussed, if you want to start a new company, your own money, then you can take a loan that is known as debt, and the third one is you can dilute the ownership. So if you are diluting this ownership to the general public, this is known as IPO. So this IPO, FPO, rights issue, private placement, all these are the ways through which you can dilute the ownership. But if you are selling to the general public for the first time, it is known as IPO. In detail, we are going to discuss this in the capital market chapter, shares market chapter. So you cannot issue IPO. A private limited company cannot issue IPO. They cannot register themselves with the SEBI, or in the sense they cannot register with NSE or BSE, the share markets. So this is what the private limited company is. The members will be 2 to 50, but they cannot issue the IPO. Then we have the public limited company. In case of public limited company, the owner should be, the number of promoters should be more than equal to 7. And they can issue even the IPO. But this, don't get confused with this word public limited. Public limited, or it is also known as limited, when nothing is mentioned. Suppose only 7 is mentioned. So by default 7 means plus 7. It is not minus 7. Similarly, if only limited company is mentioned, suppose somebody is saying Infosys is a limited company, TCS is a limited company, it means it is a public limited company. So we can say that public limited company, it can be in public sector or it can be in the private sector. If a company is in the public sector, it is known as public limited company. If it is in a private sector, it is known as private public limited company. For the first public limited company, the example is Coal India Limited, ONGC, IUL. And for private public limited company, the example is, we already discussed, Infosys, TCS, all these companies are there. Then we have the sixth or the last type of business organization. So this one-person company is a new concept in India, but it is not a new concept in case of Western world. So by Companies Act 2013, we came up with this concept of one-person company. So one-person company and proprietorship, they are related to each other. In case of proprietorship, also there is only one promoter. But the thing is, suppose this promoter has started, A is the promoter, and A started a business in cement. A now again want to start a business in steel. But there is a risk associated with this business as well as this company. Because if suppose tomorrow, unfortunately, this company who is producing steel, it filed bankruptcy. It's not working well, and finally A is forced to file bankruptcy for this company. So in that case, A has to return the money. Whatever are the liabilities of this company, steel company, A has to repay it. Now from where A will get? A will get from its own assets, or A will be forced to divert the profit of this cement company to this steel company. So A was not specializing in different businesses, different sectors, because there is a risk associated, because there is a concept of, in this first, second and third, there is unlimited liability. In case of private limited, public limited and one-person company, there is limited liability. It means in one-person company, if this happens, so A will be responsible only for the subscribed capital. Whatever A invested in this steel company, A has to repay only that much amount of money. Nobody can force A to divert the profit of cement company to this steel company, because there is a limited liability concept. And this is the reason that although the Kingfisher Airlines is about to file bankruptcy, it's not at all working from last 3 years, but still Vijay Mallya, Vijay Mallya was not forced by the government to sell the other assets of Vijay Mallya to repay the loan which Vijay Mallya's company Kingfisher Airline has taken from these different banks, because Vijay Mallya's responsibility was only till the limited liability, the subscribed capital. Whatever this guy Vijay Mallya invested in Kingfisher Airlines, Vijay Mallya was responsible only for that amount. So these are the basic things about the types of business organization. So these factual things are relevant from exam perspective. Like in private limited company, can private limited company issue IPO? This 2 to 50 is there, it's more than 7 is there. Can public limited company be in private sector, or it can only be in the public sector? What is 2-3 statements about Hindu undivided family? What is Karta? Then we have the partnership. Is there a concept of only limited liability in partnership, or there can be unlimited liability in partnership? How proprietorship is different from one person company, whether one person company is a new concept or it is an old concept. So such type of questions can be asked. Then after covering this basic, why I discuss this thing is because in this Insolvency and Bankruptcy Code, the responsibility or the process that will be used for limited liability partnership will be different. This limited liability partnership and these others, they will be clubbed together, and the individual, it means this person and this, they will be clubbed together. Anyways, we'll discuss these things under this, the next topic. So Insolvency and Bankruptcy Code. So first of all, what do you understand by the term insolvency? It become insolvent. Insolvency means whatever your financial liabilities, it doesn't matter whether you are a company or an individual. If a company is there or an individual is there, if you are not able to fulfill your financial liabilities, then you will be regarded as insolvent. Suppose you have taken a loan of 5,000 rupees, and if you are not able to repay this 5,000 rupees, then it is known as the insolvent. Then what is the need of this Insolvency and Bankruptcy Code in India? We have a number of laws. We have the laws which are related to insolvency and bankruptcy. They are like Companies Act 2013 has provisions. Then we have the Debt Recovery Tribunal. We'll discuss these things in the financial landscape. Then we can have the Debt Recovery Tribunal, for example. We'll discuss now only. Then we have the SURFACI Act. Then we can have the Provincial Towns Act. It is a pre-independence era. Then we can have the Sikh Industries Act. Then we can have, so this DRT is Debt Recovery Tribunal. Then we have Companies Act 2013. So all these different acts have something which is related to the insolvency and the bankruptcy. So it means the first need of this Insolvency and Bankruptcy Code is the financial landscape is not uniform. There are n number of acts which are related to insolvency. So it means there can be some contradiction. Maybe suppose DRT is related to the individual, SURFACI is also related to the individual. So there can be some mutual conflict between these different acts. There is no uniformity. So once this Insolvency and Bankruptcy Code will come, then it is going to amend some of these acts, and it is going to remove this Provincial Town, Sikh Industries. They are going to remove this few acts. So to make the financial landscape uniform in the financial market of India, this is the one reason of this Insolvency and Bankruptcy Code, which has already been passed by the Parliament. Then the second reason is the cost of credit. Suppose some creditor is there, maybe SBI. SBI is giving a loan to some company, maybe Reliance. So Reliance is a debtor. Now, as per these existence acts that we have, these existent acts, they are more pro to the debtor. and they have some biasness against this creditor. So SBI is not sure if something goes wrong with this Reliance, whether SBI will able to return back this my money or not. The same thing is happening in case of Kingfisher Airlines, Vijay Mallya. These banks, they landed 10-12,000 crore rupees. Now they are not able to recover it. The reason is no uniformity is there. Had there been a uniformity, the system, it was had this system was crystal clear, so there was a mechanism through which they can approach Vijay Mallya. The vice versa is also possible, because there are multiple acts related to this. So even if the Reliance wants to sell the assets, suppose Reliance knows that I am not going to be successful in this business and I want to shut down my business which is related to this thing. Now Reliance has to approach to this creditor SBI loan. Because of the complexity of the financial market, there is no systematicity. There is no mechanism through which you can resolve such problem. And when there is high complexity, it means SBI will charge more from Reliance. To whoever SBI will lend, they will charge more interest. The reason is because there is no uniformity is there. So the cost of credit is very high. Similarly, the third one is, and India is a capital starved country. We need infrastructure. We have to build infrastructure. And to build infrastructure, we need money. And to get money, you have to encourage these money lenders, these bankers, these financial institutions, whoever is lending, you have to encourage, you have to make that process simple. If you will not make this process simple, the banks, the financial institutions, this money lender, whoever is lending you the money, they will hesitate to lend you. And if they will hesitate to lend you, from where you will get this capital? From how you will develop the infrastructure? So the recovery of the loan again is very difficult because complexity is there. So this is what the need. That is why there is a need of one process. Streamlining of the process is required. And that is why this government passed this Insolvency and Bankruptcy Code. It's not like for the first time there was a need felt of the Insolvency and Bankruptcy Code. Fortunately or unfortunately, this act was never passed. So different committees are there. Just like one Tiwari Committee was there, which was of 1985. So Tiwari Committee recommended the Sikh Industries Act and it was passed. Then we have the Narasimham Committee. This Narasimham Committee, there were two Narasimham committees. We'll discuss these Narasimham committees later on. This first Narasimham Committee 1992, second Narasimham Committee. So this first and second Narasimham Committee, they also recommended a lot of reforms to make the process simple. They recommended SARFAESI Act, Debt Recovery Tribunal. So all these were recommended by the Narasimham Committee. Then we have the Justice Iradi Committee. So Justice Iradi Committee came in 1999 and this committee recommended to remove the Sikh Industries Act. Then we have this N Mitra Committee which came in 2001 and this N Mitra Committee recommended this Insolvency and Bankruptcy Code. It was way back in 2001, but unfortunately it was not accepted or the act was not passed by the Parliament. So maybe in the match the following, because this Insolvency and Bankruptcy Code is in news, so we match the following can be asked in the exam. The SARFAESI Act was passed on the recommendation of which committee? Debt Recovery Tribunal was passed on the recommendation of which committee? Sikh Industries Act was passed on the recommendation of which committee? So this match the following can be asked. Then we have what are the fresh provisions? What are the major provisions? Except that institutional framework is there. So new institutions will be developed under this Insolvency and Bankruptcy Code. But before that thing, what are the new provisions that are mentioned? So the first provision or the first major thing under this Insolvency and Bankruptcy Code, or we'll discuss these major provisions after we will cover this institutional framework. So first I want to cover this, what are the major institutional framework? So suppose this is creditor. Creditor gave some money to the debtor. SBI is there and SBI lended some 50,000 rupees to this debtor. So this debtor This debtor can be a company or it can be limited liability partnership, or this debtor can be an individual. Individual or unlimited liability. So, first of all, who can start it? Suppose SBI knows that this debtor, suppose this is SBI, this is Reliance. SBI knows that Reliance is not going to repay. So, SBI can start the process of taking the money back or selling the assets of this Reliance, or even if the Reliance knows that this business, it has stopped. Now I know that this business is not viable. It's better to sell the assets and to repay the money to the banks. So anybody, there is one process that is known as insolvency resolution process. So that insolvency resolution process, earlier it can only be started by the debtor, but now under this code it can be started by creditor as well as the debtor. So anybody can start. The only thing that you have to do is you have to file the application to the adjudicator. Whoever is the adjudicator, you have to give your application to that particular adjudicating body. These adjudicating bodies, or under this institutional framework, there will be 5 new institutions. First one will be, there will be regulator, that is known as Insolvency and Bankruptcy Board of India, or we can say board. We'll discuss it later. Then this regulator is going to regulate the functions of insolvency professional agents. Then there will be insolvency agencies. Then there will be utility information companies. And then at last there will be adjudicating body, who is going to adjudicate, who is going to decide. Now there will be 2 different adjudicating body. First one will be for this company and limited liability partnership, that is National Company Law Tribunal, and for individuals there will be Debt Recovery Tribunal. We will discuss all these individually. So first of all, this insolvency resolution process can be started by creditor as well as debtor. This is the first major thing under this new code. So this insolvency resolution process can be started by any creditor as well as debtor. Then what exactly this insolvency or resolution process is? It is nothing but a negotiation. It is a negotiation process between the creditor and the debtor. So suppose this debtor has borrowed 100 crore rupees. Now there are some negotiation going on. So negotiations for what? Negotiation to decide the resolution plan. What is the plan? How you are going to repay? You are going to repay this 100 crore rupees in the lump sum, or maybe in 1 year, 5 year, 4 year, whatever that resolution plan is. So there will be the negotiation. Under this insolvency resolution process, there will be negotiation between debtor and creditor to finalize the resolution plan. And this resolution plan will be submitted to the adjudicating body. Now because this creditor has its own interest, this debtor has its own interest, so there should be some independent individual who should overall review this insolvency resolution process. That individual is known as insolvency professional agents. So what is the role of insolvency professional agents? They are going to review, or they are going to help the creditor and the debtor to finalize the resolution plan or during the process of insolvency resolution process. Also, there will be one more function of professional agents, that is, suppose this debtor is a company and this company is having 3 promoters, A, B and C. Now when this company knows that I have to file bankruptcy or somebody is going to come and going to take my money, so maybe they can sell the assets during that insolvency resolution process. When this process is going on, when there are negotiations to finalize the resolution plan, it is very much possible that this company will sell some of its assets. So during that insolvency resolution process, all the assets of this company, for the time being, they will be transferred to this insolvency professional agents. So whatever decision these promoters A, B or C, they have to take the permission of this insolvency professional agent. So this insolvency professional agent, finally this professional agent is going to pass that resolution process, or this professional agent is going to submit that resolution plan to the adjudicating body. So once this is finalized, then this professional agent is going to submit the resolution plan to the adjudicating body, whatever the adjudicating body is, whether it is NCLT, National Company Law Tribunal, or it is the Debt Recovery Tribunal. But the thing is, the time is fixed. It's not like for years and years and years your assets are locked. Suppose bank is there and you have not returned the money. So what bank will do? The bank is going to attach your property. Whenever you are taking a loan, you have to give some mortgage or collateral. So that collateral now belongs to the bank. And suppose in between A goes to the court, and suppose A this company, and for years and years and years, we have more than 3 crore cases pending in the court. So there are like years and years of the pendency. So till these maybe in 5 years this case will be decided. So for 5 years the assets of the bank or the assets of this company, they will be freezed by the bank. Just like in case of Sahara, the Supreme Court freezed the assets of Sahara company. So it means the assets, they will be freezed, and that is a loss not only for this bank and this company A, that is a loss for the full economy, because India is a capital starved company. We need money. On the one hand we need money, on the second hand these capital, it has been locked maybe by the order of court or maybe the negotiation process, whatever. So what the need of the hour is, the time frame should be fixed. Whatever you have to decide, whether the creditor agrees or the debtor agrees or finally there will be order of the adjudicating body, it should be done in a fixed time. So that is why the time frame for individual is different and the time frame for this company and limited liability partnership is different. For these guys it is 180 days. So within 180 days this resolution plan should be finalized. If the resolution plan is not finalized within 180 days, the adjudicating body is going to liquidate the company, or in case of individuals, you will be forced to file bankruptcy. So within 180 days you have to finalize it. There can be an extension of 90 days only in exception circumstances. If 75% of the creditor agrees, whoever is lending you, it's not like only one creditor pays you, because there is a more risk. Suppose you are starting a business, just like the Kingfisher Airlines. So in case of Kingfisher Airlines, it's not the individual SBI which landed. There was a club, there was a group of bank, a consortium of bank which landed. Maybe SBI landed 5,000 crore, ICICI landed 2,000 crore, some other bank landed 1,000 crore, 500 crore or something. So there will be consortium of banks. The reason is that is going to decrease the risk of the individual bank, because the need of the Kingfisher Airlines is, if suppose 10,000 crore. So Kingfisher Airline needs 10,000 crore. But if one bank is going to land this full 1,000 crore, there is a lot of risk which is which the bank has to face. So to avoid such circumstances, the banks, these banks, they make a consortium, and this consortium, this group of banks, they will lend. The amount can be different, but there will be some group. So if 75% of these creditors, they agrees to increase the time, so it can be extended for 90 more days. So at max it is just 270 days. Within 270 days you have to decide how this debtor is going to return the money of creditor. It means the resolution plan is fast, or this adjudicating body will sell the assets of this debtor. It means it will be the liquidation of the company. So within 270 days, either of these two things is going to happen. So if the resolution plan is passed by this adjudicating body, so under that particular resolution plan it is mentioned, maybe in 5 years I'm going to return all these things, maybe in 4 years, 3 years, or 2 years, whatever the time frame. In case of individual or this unlimited liability, it is 6 months. Within 6 months or 180 days, you have to decide it. But because individuals or unlimited liability companies, they borrow less, and these are the poor chaps, we cannot say they are not the rich people. So the process for individuals should be different. It should not be like this. So under this individuals or unlimited liability company, there is a mechanism, there is a process that is known as a fresh start. Fresh start says that if your annual income is less than 60,000 rupees plus your debt is less than 35,000 rupees, this is your income and this is your debt, this is what you have to return. If you are fulfilling this criteria, then you can give an application to this professional agent, and this professional agent will represent your application to the adjudicating body. But for individuals, the adjudicating body is DRT, and for this the adjudicating body is National Company Law Tribunal. You know, this NCLT, it's not a new concept of this code. The provisions related to National Company Law Tribunal is already mentioned in Companies Act 2013, but it has not yet been established. So at present the mechanism is, there are companies, there will be a special bench of the High Court. So companies court are there, so that bench is going to decide these cases. But once this Insolvency and Bankruptcy Code will come into picture, or it has been passed, when it will be implemented, so a new National Company Law Tribunal is going to resolve the cases of this company. And suppose somebody is not happy, if a company is there A, and A is not happy by the final decision of this NCLT, so finally they can go to the appellate tribunal. And if you are not happy with this, financial appellate tribunal is there. If you are not happy with this, then you can go only to the Supreme Court. You cannot go to the High Court. So that is going to decrease the time of the final decision, or that is going to decrease the freezing of the assets. That is what the major problem is. So the Companies Act is there, and in the case of individual or unlimited liability, it is only 6 months. So if these provisions are there, if your annual income is less than 60,000, if your debt is less than 35,000, then adjudicating body, it means DRT, can decide, they can give you a fresh start. Fresh start means you don't have to return this amount of money. So that can be decided by the adjudicating body only and only if you are fulfilling this criteria, and this is known as the fresh start provisions of Insolvency and Bankruptcy Code 2016. Now suppose within these 6 months or within these 180 plus 90, it means 270 days, if this resolution plan is not finalized, or not, either it is not been accepted by creditor and debtor both, or the adjudicating body has not accepted the resolution plan. Suppose they have finalized, this professional agent has given this resolution plan, and this adjudicating body says, I don't agree with this particular resolution plan. So in that case, the provision is, if this is the adjudicating body, if they agrees, then not a problem, that resolution plan will be implemented. If they don't agree, then in that case, this individual or unlimited liability company, it has to file bankruptcy, and this company or the limited liability partnership, they have to liquidate. Liquidation is going to take place. Liquidation means whatever will be the assets, they will be sold in the market. A trust will be developed, and finally that trust is going to sell all the assets of this particular company. So whenever you are going to sell the assets, it's not like this company, this debtor owes only the debt. In case of Kingfisher Airlines, remember that the pilots, they went to the Supreme Court and they said, we have not got our salary of last 6 months, of 1 year or something. Maybe the government, the state government or the central government, they also gave some amount of loan to this. So whenever you are liquidating any company, there should be a priority list. On what priority you are going to repay the debts. No, this can be the liquidation, the claims can be the shares. It means the owner. Vijay Mallya must also be having the shares of the company Kingfisher Airlines. It's not like if this is the scenario, when the assets of this company will be sold, Vijay Mallya will also get something. It is not such something like that. If once you will cover all this list, and if something is left, then only the shareholders will get something, because shareholders, they are the owner of the company. Before these shares, we have preference shares. This we discuss later on in the securities chapter. Before preference shares, there can be, suppose somebody gave you a loan. Now, what do you mean by that somebody? Whether that somebody is an investor, whether that somebody is the central government, whether that somebody is the state government, or whether that somebody is a bank, who is that somebody? So this code has changed this particular priority. Earlier, at the second place, it was the state and the central government. But now, first priority will be insolvency cost. So whatever cost is going to come, this debtor has to repay, and that got the first priority. Then after that insolvency cost, there will be secured securities or secured creditors, we can say. If you have given a loan to this company, so that will be the secured creditor, and then there will be wages of the employees, and then there will be state government and the central government. So this has changed this thing. Whatever the claims, the priority of the claims, it has been changed by the Insolvency and the Bankruptcy Code. This is the priority of the claims, and this is the fresh start. Then we will discuss a new structure is going to come, and under that new structure, first of all, a new regulator is going to come. Just like in case of the banks or the financial institutions, we have RBI. So similarly, a new regulator is going to come, and the name of this regulator will be Insolvency and Bankruptcy Board of India. Just like what is the role of RBI? The role of RBI is RBI regulates the bank. Similarly, this board is going to regulate all these things, except this. Adjudicating body will be separate, but this regulator is going to regulate the professional agents. Now all these professional agents, they will register with some company. That company is known as insolvency agencies. So these professional agents, they will register with the insolvency agencies, and we discuss the functions of professional agents. Two function: they will help in the negotiation of creditor and debtor to finalize the resolution plan during insolvency resolution process. And the second is, whenever this insolvency resolution process is going to take place, whenever it is happening, the assets of the company, they will be regulated by the professional agents, and these agents, they will register with the agencies. So these agencies will, maybe they will register, they will prescribe the model code, how this agent should behave. So all that will be the function of the professional agencies, insolvency agencies. Then we have the utility information provider. So the role of the insolvency utility provider or the information utilities, that will be, they will create a database, they will create the financial information, just like right now we have the rating agencies. Just like there is a very famous Indian rating agency that is known as CRISIL. Similarly, we have 3 other international sovereign rating agency. Sovereign rating agencies, it means they are giving rating to the sovereign countries. They will give rating to India, they will give rating to USA. So first we have S&P, then we have Moody's, and then we have Fitch. So these are the 3 international sovereign rating agency, and we have CRISIL, that is the local one. So the role of these rating agencies is the rate. How, if suppose some company is going to come up with an IPO, they want to issue the shares. So this rating agency will give, yeah, this I am giving AA plus, or I am giving AAA plus. And how they are giving this rating? Because they have their database, the financial information. Regularly they are collecting the financial information from the market. And similarly, related to this, these information utilities, that will be the work of information utilities. They will collect the information, they will collect the financial information, the viability of the business, and that information they will help during that insolvency resolution process. And then there will be adjudicating body. For companies it is National Company Law Tribunal, and for individuals it is Debt Recovery Tribunal. And then finally the critical evolution, whether this is good or bad or something. So it is regarded as a major milestone in the financial history. It's a very, very big reform. So it is going to streamline the process that we discussed. It is going to simplify the process. N number of acts were there, is going to be removed by only one single act. Similarly, it will be time bound. Now because it is time bound, so within 270 days you have to finalize it, whether you want to liquidate or the resolution plan is finalized, whatever the thing is, but that is a time bound, so it will be fast. But few critics, they are saying that on the one hand we have creditors, it is creditor 1, it is 2, it is 3, it is 4, and there will be a single debtor. So the thing is, the interest, there will be a natural conflict in the interest of 1, 2, 3 and 4, and that final resolution plan, it will be passed by the creditors only. There will be voting. So if 1 and 2, they want that this company should file, this company should be liquidated, and 3 and 4, they want that no, I want to decrease my loss, I don't have that much of time, a resolution plan, it should be finalized. Now but you are clubbing these creditors. In one hand they will be clubbed in the single thing. So that clubbing of creditors who have a natural conflict of interest, so that may create during the actual implementation of this insolvency resolution process. Maybe few of the creditors, they will agree for liquidation, other creditors, they want the resolution plan. So there will be a mutual conflict between this. So this is what about the Insolvency and Resolution Code 2016. In the next lecture we will discuss about the FRBM Act, we will discuss. Then one more committee is there, Chilaiya Committee, we are going to discuss. And then we will start with the GST, VAT, GST, and all these major reforms we are going to discuss in the next lecture. So thanks a lot.